the California State Bar to really start to set standards around this, hard and fast standards. But they do, we do have 3 good ethics opinions in California that touch on this area. And so that's kind of where we're at. But you also have, or we have, for the lawyers in the room, this heightened obligation because of these ethical considerations, right? So if you think about a business, whenever I get a call about an incident, I tell them, first thing in all the communications, a data security incident is an objective fact. Data breach is a conclusion of law, right? So, and that's all they're really worried about. Is this some sort of protected information that, has become vulnerable in terms of its confidentiality, integrity, or availability, right? And so that's it's actually kind of simple. But as lawyers, we have a problem that's greater than that because we have this ethical duty of confidentiality of whatever information is given to us by our clients, right? So it doesn't necessarily have to be PII. It might be trade secret information, or as the first panel said, M&A information, all sorts of things. And when I think about the threat vector, everybody worries about the black hat hacker, right? And that's the big threat. For me, as a lawyer and in law firms, the things I look at are hacktivists and insider threats as really the things that we can do the most about, and then nation-state actors, right? And the reason I say that, if you look at the history of publicized law firm data breaches, some of the biggest breaches have been hacktivist breaches. The first breach was a law firm that specialized in defending soldiers who were accused of war crimes in the Middle East. And hacktivists hacked their system and threw all these clients' confidential information up on the web and defense strategies and all of that, and took down this firm. And they did it as a political statement about the fact that they were defending war criminals. The idea of innocent until proven didn't matter to the hacktivists. And then you look at the Panama Papers, and more recently the Paradise Papers. I'd like to ask a question: how many of you heard of the Applebee hack? So maybe 3 people. They think it's the restaurant. Actually, Applebee is a law firm. It has a subsidiary called Astera, which does treasury. And I had 3 clients. Their first call was, do we have a problem in terms of a reportable breach? The answer is no. Do we have a problem? Are we a victim? And the answer is yes. And the vector was, PR guy gets the call saying, this is the New York Times. We're going to go to publish a story in 2 weeks that illuminates how you manipulate our offshore tax havens. And we got your data from this law firm in Bermuda, right? So, hacktivism is a big problem. And then I've also worked the insider threat problem. Law firms, you get in and it's wide open because we want to collaborate as lawyers and we trust everybody inside the environment. And I worked a case, an associate that worked at 6 big law firms, and over a period of 19 years, exfiltrated a ton of M&A data, gave it to a trader who made $9 million trading on that data. That's an insider threat. And he didn't even actually open files. He just looked at the listing of files for new client matters and also the kinds of documents that were being loaded into the document management system to figure out what the transaction was about and trade ahead of that transaction.
Great. So I think we're starting to see some real-world examples of how this is implicated. So, and we did actually kind of cover the second question there a little bit, and I want to be sure to get to our ethics examples. So, more real-world implications and guidance, and we've included in the materials that are available on the website for this event. For this panel, I think you can just click on MCLE materials, and then we've got some PDFs. So we have these 3 opinions, and then we have another helpful document that we'll talk about in a second that discusses what lawyers can do in terms of when they're experiencing that second situation there, which is moving your practice into the cloud and things you can do to protect yourself. But let's look at this first question. So. Basically, what should you do if you need to go to a coffee shop and do some work on your laptop?
Bring your own Wi-Fi.
Is that a good idea? Is that a bad idea?
No, I think people don't realize, and even here today, like when you join public Wi-Fi networks, there's no security there. None of that information is confidential. In fact, a lot of the reason you're getting free Wi-Fi is so that they can mine the data and study how people are using it and build better, bigger Wi-Fi off of you. So just being, I think, basically cognizant of those types of things that you either can, very simply, and my team and I just recently talked about this, tether to your phone and use your phone cell service, or in the alternative, bring a company hotspot and bring your own Wi-Fi. I think is my biggest advice.
Yeah, if you go anywhere in San Francisco and spend a little time in some of these cafes, you'll see this happening constantly. Attorneys working, having phone calls like it's their office. It is insane. Don't do it. Oh, wow. But yeah, I mean, the ethics opinion that we have in the materials, it deals with the New York lawyer, right? Don't use public Wi-Fi if you can, unless there's an emergency. That's the only time. But the risks are too great, and I mean, it's not even nobody's going to do anything. It happens a lot. So.
Especially in the Bay Area where there's a lot of sophisticated actors.
Yeah.
It's a real threat.
Well, and it's so many layers deep, right? So you have to pay attention. And the first problem, and I see it a lot, I divide this problem up into my personal information, my personal professional information, and my firm information, right? And so some of it's going to be controlled. And so the first step is you have to understand at a basic level what your system, and it has to be more than, I let the IT guys worry about this, or I let the InfoSec guys worry about this. You have to have a basic understanding of what they are doing in the background to try to save you from yourself. So, I went onto the public Wi-Fi here just to see what was going on, and I could not get into my firm's email system directly. It was blocked. I also, because my personal security settings, couldn't get into iCloud and get my me.com email. It was blocked. It already knew that I was on an unsecured private or public network, and so it wasn't going to let me do things. And that's the trend. But because that's the trend, people tend to become complacent. And you really can't become complacent because the threat's out there, right? And the bad guys are constantly trying to weave around those kinds of systemic methods to protect us from ourselves, right? So, if you're using good quality VPN and it's configured properly on your endpoint as well as with whatever system you're trying to connect to, then public Wi-Fi is okay, because either you're setting up a secure tunnel that's not vulnerable, or properly configured, it will be blocked and you won't be able to get in. And that opinion is a 2010 opinion that predated a lot of this technology, although the technology was probably there, it wasn't implemented as broadly as it is now. So understand a little bit about the systems that you're using and the protections that are there, and leverage that to your benefit to enhance your personal productivity, as opposed to making that something that gets in the way.
Right, and going to sort of, analogizing this to the business context where, you're a large business, maybe like the company I work for, and you're basically hoovering up data from your clients' systems all day long, and then tasked with protecting it so that they can access your, access the value you're trying to deliver them, but you're trying to meet that duty you have of confidentiality, right? It's a contractual duty for our business and our customers. In this case, as a lawyer, it's a background duty of the profession, right? And there's all sorts of exposure that's not just, not just an ethics opinion being the subject of that. There's client trust issues that arise just the same as a customer walking away from the business that I work with because they didn't think our security was up to par or our practices were reasonable. So it's just sort of, I think, try your best not to have to be in the situation where you're in a Starbucks working all the time. But the other thing to do is to educate yourself a little bit and try to figure out, okay, if I have to work out of a Starbucks, what am I going to do? What's my plan? What's my backup, right? How am I going to make this work? So to Kate's point, have a hotspot ready. Try to figure out if you have access to a VPN that's configured properly and makes sense for your use case, right? There are different ways you can attack this problem. And again, Wikipedia could be your friend in some of these areas, just to get up to speed on, some of the terminology. It's a good place to start. So talking about kind of tools you can use, the next opinion that we share with you guys in the materials is really about lawyers moving their business to being sort of virtual law firms, right? Using cloud-based services, the magic of the cloud, taking all of your client information and you don't have to set up a network, you don't have to manage hardware and manage all the configurations of the firewalls and all the things that you have to do to protect that information. If you're storing it on site, you can give it to some vendor and they'll do it for you. So what do you guys think about lawyers adopting the cloud, and what are some basic steps that lawyers can take and consider when they're thinking about following everyone in that direction?
So I'll start. So I'm a big fan of the cloud because, in my opinion, a well-developed provider who is concerned about these kinds of things is much better at security than the average law firm, much better. But there are some caveats, obviously, and the first is understand, the technology that you're getting and what the various obligations. First, negotiate. Don't go. Let me back up a step. There's consumer cloud and then there's enterprise cloud. You do not want to be in the consumer cloud space. If you can go online and just click through a bunch of boxes and suddenly you've got an account and data is flowing, that's bad, right? That's a bad thing. So you want to get into the enterprise cloud space, and you want to vet how that cloud provider is going to handle your data, and there's some nuance to that. So as an example, you have file sharing, and the two big names, Dropbox and Box, and I've represented them both in my career. And I can tell you, and I share this publicly a lot, Dropbox was started to go viral and dedicated to more of a consumer cloud privacy and security model. They've been hacked twice. Box was started from the ground up to provide enterprise level security in those transactions. So if you're a law firm and you don't want to do a lot of due diligence, you should probably be starting your negotiation with Box, and then maybe comparing it to enterprise Dropbox. And if there are people from either company here, I apologize, but that's my opinion. That's my opinion, not the opinion of the firm. And there's all sorts of nuance like that across the board to the kinds of systems that you can tap into to leverage what you're doing.
So to that point, so when I think you mentioned the diligence aspect, right? And I think that's kind of the theme of this whole thing is sort of know some basics about what you're getting into and the technology you're using and where data is flowing and where it's sitting and how it's transmitted. One of the other documents we shared with everybody it's got a very long title, but it's from the Association of Corporate Counsel, and it's the Model Information Protection and Security Controls for Outside Counsel Processing Company Confidential Info. So, mouthful, but it's essentially a really good set of guidelines that you could use to help in your diligence process and program when you're trying to figure out what cloud providers could be useful in your practice, whether you're, if you're in a smaller practice, less leverage, less negotiation power potentially with some of these enterprise providers. They might be less willing to amend their agreements with you and their obligations to you, but they should be in a position to answer questions. And so this document that we have here will give you at least a flavor of the issues that you should be concerned about or educating yourself about. And it's designed as a contract amendment as well. So I think you could probably take it, edit it, if it works for you. It's not legal advice. They have a big disclaimer at the top, but if it works for you and your professional opinion, for you and your firm or your client, that's actually a very good starting point to sort of attach to a contract as an extra set of obligations to put on that vendor. But it also is a good source for your diligence review, and gives you some areas you may want to poke into a little bit more with that vendor if you have the chance. So that we've shared that document with you as well. And I think
Can I just comment really quick?
Go ahead.
So it's vital that whichever providers you use, you read the privacy policies and the terms of use and all of those documents. It's really annoying and it's boring, unless you're me, because I like that stuff, but that's going to tell you what your rights and obligations are. I know that you all know that because you're here and you're interested in that sort of thing, but it's surprising how few people actually read those documents in this specific area. You may not do it in the rest of your life, but in this area, it's vital because that's going to tell you if you have any sort of problem with your privacy under the ethics rules.
So I would say, the other thing I want to point out is that the ACC did a good job of putting this together, but it's somewhat of a compromised document. And how many of you are familiar with CLOC, Corporate Legal Operations Consortium? Anybody? They put together a working group to create a counter model rule set around how they should vet outside counsel for security and privacy issues because they don't like the ACC version. So there's a lot of churn there. Probably the best example of this churn is I've been involved with an engagement agreement with a financial institution that said, you and your firm will never put anything on a cloud service, which was difficult because we had another client who had big cloud services and said, all of your transactions with our legal department will be through this cloud service. And how do you resolve that cutting edge technological tool set in one engagement agreement against this absolute prohibition in another engagement agreement? And so that's another challenge. But if you're a company, if you're in-house and you don't have these kinds of clauses in your engagement agreement with outside counsel, you should, and that document is a good place to start. If you're outside counsel and your clients don't have things, that's an opportunity to kind of build some things in and set a framework for how you want to engage with them, which becomes a competitive advantage. And I can tell you, after going through an RFI for a cloud service, the final 4 competitors, and we were going to sole source this legal outsourcing activity. The final 4 competitors, 2 of them could not, and would not aver that they complied with the critical security controls, which is a minimum standard for reasonable security in California. And so they lost the business. They were, features and functionality, probably the incumbent, but they lost the business because it goes into every one of the contracts that we negotiate for our clients. It goes into everything that we do now as a firm, is that they're either ISO 27001 certified or they will aver that they meet the critical security controls, period. It's not negotiable.
Yeah, and I think being in-house, I've seen in-house counsel get increasingly aggressive about these requirements with outside counsel, and I am very empowered to do the same. I mean, we are an entirely cloud-based system, offering, process, procedure. We run on a variety of cloud services, and I need all of my lawyers outside to do the same. So at this point, only receive guidance from outside counsel via Google Doc. I've ensured that they can meet those systems and work within our environment because, I don't really trust their law firm security. These big law firms know security like they know, a tech company. So I'd much rather like set them up with an account and within our system and allow them to like securely operate in a manner I'm comfortable with, and like set that up with them by a contract to make sure that they only store my information that way and only for whatever period of time. And if they don't want to do that, if they're not comfortable operating that way and don't understand that either the technology or the systems, then great. You know, there's 100 other law firms that are happy to do the job that they're doing. So definitely make sure that you're aggressive in protecting those assets.
Kate, that's a good point. So on the other side, being outside counsel, in my retainer agreements, I have a policy, or privacy policy and cloud clause. It's kind of a tiered thing, where the first thing is I require that my client give me a computer with whatever they want as far as security installed. So I can use that, and then when I return it, I can return it to them, and then there's not a file issue later on. If they don't want to do that, then they have to give me